an internal report that was withheld from her, where the investigator said, I found no evidence of theft. Notwithstanding that, Joe Hamilton was charged with theft by the post office. That was knowingly withheld in the sense that the investigator's report went to the acting head of legal within post office.
Let me ask you first. You were appointed, weren't you, as a forensic auditor? You were called in by the post office to conduct an independent investigation. That was after being approached by victims and by MPs. Among your many interesting, fascinating findings, you found clear evidence that accounting systems at individual post offices were accessed remotely, often after hours. Now, that in itself is maybe not abnormal. So let me ask you, were accounts then altered in a way which strengthened the case against postmasters and postmistresses?
It certainly had the potential to be altered, and what was of particular concern, and this arose after my visit to the headquarters of Fujitsu in Bracknell. Whilst they knew who was accessing the data and when they were doing it, they weren't keeping a record of any changes that were made and so on, and the impact on branch accounts. Now, as soon as I heard that, I realized that we were looking at potential manipulation of data. And therefore balances that may not be reliable and were not under the sole control of sub-postmasters, which of course was the assumption that everyone had made up to that point.
Right. So just to be clear, though, it's possible that data that became evidence was altered, but you can't be sure of that. It is just simply a possibility.
We can't necessarily be sure of that. We were investigating that level of detail. We were looking at log files, we were looking at what's called XML transactions. And that was at the point at which we were sacked by post office.
Yes.
And we were prevented from any further work.
Right. Now, Ian, this is a very important point. Did you find evidence that managers within the post office knew that postmasters and postmistresses were being wrongly accused of fraud?
Yes, I did. And Joe Hamilton was perhaps the key case where there was an internal report that was withheld from her, where the investigator said, I found no evidence of theft. Notwithstanding that, Joe Hamilton was charged with theft by the post office.
And did you have then, I mean, this is a shocking suggestion. Did you find evidence, and I stress evidence, something which is provable, something which is there in black and white and in solid form, you found evidence that this was done knowingly and not just in one case? This was something which was something of a pattern. Would that be correct?
It certainly had the potential to be a pattern. There were other cases that we found, which I can't name for reasons of client confidentiality, but there were other cases where we came across similar examples of documents being withheld from sub-postmasters that were relevant to a criminal prosecution.
So evidence that was submitted in court that was part of a case against individual postmasters and postmistresses was in effect false testimony. That's what you're telling me.
No, I'm saying it was withheld from the disclosure requirements. I mean, at the time, there was a code of conduct for prosecutors. They had a duty, in my view, to disclose relevant evidence that supported the prosecution or indeed led you away from the prosecution. And certainly in Joe Hamilton's case, we found significant evidence of the fact that the investigator found no evidence of theft. That document was withheld from Joe Hamilton.
Right. So to be absolutely clear, evidence that would have been useful to a defense, to a defending lawyer, or to a postmaster or postmistress at that point in the dock facing possible imprisonment, that was withheld. And you can say that was knowingly withheld.
That was knowingly withheld in the sense that the investigator's report went to the acting head of legal within post office.
Right. Now, you found this. Were you able to pass on those concerns to the post office? And if you did, what did they say?
Well, our report was very critical of Horizon. And bear in mind that our initial work started in 2013. Post Office reluctantly agreed to a mediation scheme whereby 140 applicants entered mediation. That mediation process was confidential. We don't know the outcome, but ultimately it led to what's called the Group Litigation Order trial, the GLO trial in 2019. And that's when this all started sort of coming out into the open.
I mean, and without asking for names for obvious reasons, who were these managers, these officials, who were sitting on evidence of innocence and not putting it, as should have been done, into the case and into the court system?
Well, when I was looking at the case files within Post Office, I was based in the legal department in the head office of Post Office. I'm not going to name the people I was dealing with, but it was absolutely clear that Joe Hamilton was not an isolated case, and there were other former sub-postmasters that were in a similar position.
Right. Now, Ian, you are a forensic accountant. You're not a lawyer. I'm going to be talking to a Supreme Court justice, a former Supreme Court justice, about this. But as a forensic accountant, you know the law. Withholding evidence, knowingly withholding evidence that is vital to a prosecution that could prove innocence, and doing so, I stress, knowingly, surely that amounts to criminal conduct. Surely that is perverting the course of justice.
Well, I was very alert to that possibility because, notwithstanding the fact that I am a forensic accountant, I had previously worked for the Criminal Cases Review Commission. I'd spent 4 years working part-time for them, and I was very alert to miscarriages of justice, and that perhaps made me particularly sensitive to non-disclosure and the fact that there were relevant sort of documents that I felt should have been disclosed to the former sub-postmaster and were not. So without that background, without that experience, I might not have been quite as sensitive to the non-disclosure than I was.
Right, and you found clear evidence of miscarriages of justice. But miscarriages of justice can happen accidentally, can't they? Here we're talking about deliberate acts of omission, but deliberate acts nonetheless, which seems to me, as a non-lawyer, cases of potential perverting the course of justice. Am I wrong about that?
What struck me was we were not looking at a single isolated case. Mistakes can happen, documents can get lost and so on. But we were looking at a number of prosecutions. We were looking at a number of files within the legal department of Post Office, and I was beginning to see a pattern occurring. And certainly when we got to the mediation working group, where we had 140 applicants, there were clear patterns of activity by Post Office that led me to the conclusion we were potentially looking at misconduct by prosecutors, because of course Post Office was acting as a private prosecutor at this stage, and also miscarriages of justice.
Well, indeed. And if it came to, we shall see, if it comes to charges being considered, charges being leveled, charges being brought in court for such accusations as perverting the course of justice, you would then be, I presume, a potential witness. Would you be ready to appear as a witness in such a case?
I would have to seek legal advice on that, but in principle, yes.
And as we know, the consequences of that are serious.
Absolutely, as they should be.